invited him in today's hearing. We likewise directed the committee secretariat to issue a subpoena regarding the production of pertinent documents. Among others are the deed of sale of the multinational subdivision lot, including the tax returns. That includes also the ITR of spouses Roque and Biancham Corporation. That includes even the SALN from 2016 to 2022. And we even required a trust agreement, which he made mention when he was asked about the transfer of shareholdings from spouses Roque to Attorney Percival Ortega in 2020. Notwithstanding the pronouncement of the committee about the issuance of the subpoena, although the same has not been served to Attorney H.Roque, this representation, and I understand the committee as well, is in possession of the motion to quash the order of the Quad Committee requiring him to submit these documents. And with the permission of the chair, I wish to enlighten the committee why this should be denied. Among the issues that were raised, Mr. Chair, number one, the documents which are being required according to Attorney H.Roque are not relevant. Contrary to what he said in the case of Arnold versus Nazareno, this is July 18, 1950. There are two tests for the relevance of documents. One is its materiality to the subject matter, and second is its materiality to the purported legislation. With respect to its materiality to the subject matter, let us remember that one of the controversies that we are investigating right now is the POGO operation. Amid the overwhelming circumstantial evidence of his connection, Attorney H.Roque's connection to Lucky South, the POGO operation, he vehemently denies this connection to the same. In the last hearing, he even articulated that his money did not come from POGO. I wish to remind the committee that during those time, Attorney H.Roque was the presidential spokesperson, a government official whose income is very much limited. This notwithstanding, we were able to show to the public the sudden increase of his assets in Biancham Corporation and the other subsidiaries. At this point, Mr. Chair, I maintain that the documents which are being required are relevant to the subject matter of the investigation. Because if H.Roque will not be able to prove the sources of his assets, then there is a possibility indeed that will support his connection to this POGO operation. With respect to the relevance to the purported legislation, possible legislation, if we are able to prove, Mr. Chair, that the documents will support Attorney H.Roque's involvement to POGO operation, the committee will likely consider revisiting and amending, among others, RA 3019 or the Anti-Graft and Corrupt Practices Act, the Code of Professional Responsibility of Government Officials, Anti-Money Laundering, Corporation Law, and even the Code of Professional Responsibility and Accountability for Lawyers. The foregoing is apart from the need to amend various laws which we have established already. For one, the PSA Charter concerning the fictitious birth certificate that we have discovered already, the immigration law concerning the issuance of visa, the PAGCOR Charter concerning the licensing of POGO, and at least the cybercrime law, which is RA 10175. Second, Mr. Chair, he invoked his right against self-incrimination. I wish to share the case of De La Cruz versus People. Ito pong right against self-incrimination ay ginagamit lamang sa testimonial evidence. And what we are requiring from Attorney Harry Roque are object evidence or documentary evidence, and therefore not covered by the right against self-incrimination. Third, Mr. Chair, he invoked his right against privacy. In the case of Standard Chartered Bank versus Senate Committee on Banks, it pronounced the long-standing case of Sabio versus Gordon. The right of the people to access information on matters of public concern generally prevails over the right to privacy. In other words, in the hierarchy of rights, Mr. Chair, mas mataas po ang right to information kaysa sa right to privacy. Finally, Mr. Chair, he likewise invoked his right to due process, two important elements of due process, notice and hearing. And we are all witnesses that we have been according this right to him since day one of the Quadcom hearing. In this light, Mr. Chair, I respectfully move that we deny, we disregard the motion to quash that was filed by Attorney Harry Roque.
Thank you, Congresswoman Luistro. There's a motion to deny the motion to quash presented before the Quad Committee by Attorney Harry Roque on the subject of subpoena duces tecum on several documents required by the committee from Attorney Harry Roque. Is there any second?
Second, Mr. Chair.
There is a motion, duly seconded. Are there any objections? Hearing none, the motion is approved. The committee denies the motion to quash of Attorney Harry Roque.
Mr. Chairman.
Congressman Padua.